adjunct professor at the law school in addition to his practice. Douglas McK Brown came to play a role as leading counsel during the post-war period and until his untimely passing in 1982. And through the lectureship in his name, the Allard School of Law appoints a distinguished visitor to participate in the intellectual life of the law school. So we are very grateful to the many alumni and members of the legal community who have contributed to this endowed lecture here at the law school. So this year's distinguished visitor is Professor Aziz Z, a scholar of US and comparative constitutional law at the University of Chicago. He has worked on topics ranging from democratic backsliding to regulating AI. His award-winning scholarly work has been published in several books and leading law reviews, social science and political science journals. He's also written for the Washington Post, the New York Times, Dissent, The Nation, and many other similar publications. He's clerked for Judge Robert Stack of the US Court of Appeals and Justice Ruth Bader Ginsburg of the United States Supreme Court. Professor Huck is the Frank and Bernice J. Greenberg Professor at the University of Chicago Law School and Associate Professor in the Sociology Department. His books include How to Save a Constitutional Democracy, The Collapse of Constitutional Remedies, and The Rule of Law, A Very Short Introduction. So his work on AI and constitutionalism has been published in the Harvard Law Review, Daedalus, and several other scholarly venues. Do we have our Zoom folks back? So just before I turn the podium over to Professor Huck, I'd like to, for the folks on Zoom, if you experience any technical difficulties, please reach out via Zoom chat for assistance. Please be sure to direct your question to host. We have additional colleagues on the line whose webcams are off, but they are assisting on the back end. We have a short Q&A following the lecture. For those in the room, of course, we'll take questions. For folks on Zoom, if you have questions, please use the Q&A box to submit them. And with that, Professor Huck.
Thank you so much. Thank you so much, Dean, and I'm so grateful to you for the invitation to come and spend some time in your marvelous law school. I'm very grateful also to Associate Dean Graham Reynolds and to many of your colleagues who have helped make this visit a remarkably intellectually rich one. It's been an honor to spend some time with such a marvelous faculty and group of students. I'm really also grateful, and I should explicitly recognize the members of the staff who did a great deal to facilitate the visit: Andrea Chung, Patricia Panaflora, and Sadia Saeed, who all gave their help with details, large and small, logistical and substantive, in ways that made this visit possible. And then finally, I'm really grateful to my students who are in the intensive class that I've been teaching. We've had four long discussions, 3 hours apiece, which I take it is a demanding amount of time, especially relatively early in the morning for a UBC student. I guess 9:30. I've been told is outside the norm, but you've all stepped up to engage and we've had some, from my perspective, have been terrific discussions. And the 2 weeks that I've been here have been full of fresh ideas, perspectives that are new to me. From my perspective, this is a marvelous way to keep my own thinking fresh, to keep my own scholarship sort of from falling into a rut, and to make sure that I am engaging beyond my normal comfort zone. I hope that's a little bit of the benefit for the colleagues who I've been talking to and the students who I've been talking to, that there's, again, a kind of fresh perspective that's bringing a bit variety or a different voice into the intellectual life of the classroom and the school in a way that befits the bequest upon which the lecture is based. So I'm grateful to all of you for those things. My remarks today concern the way in which the nation state is regulating new digital technologies, in particular forms of AI. And the comments derive from a forthcoming review essay with the same title as the talk, The Geopolitics of Digital Regulation, that's forthcoming in the Chicago Law Review. It may be worth just saying that why I selected a review essay rather than a substantive article for the purposes of the lecture or to draw material from for the lecture's purpose. As I understand it, the lecture is both intended to complement the intensive class and also to be something that is open and accessible to an audience that has not been participating in the class, and trying to triangulate those two objectives to speak to the people who I've been holding discussions with over the last 2 weeks, but also to speak to a larger audience and at the same time talk about something that is a novel or a forthcoming piece of work. All pushed me toward this particular piece of scholarship, which is not, I understand, a traditional focus of a lecture. I hope it will serve, or at least the pieces of the article that I will elevate for the purpose of the lecture work well for the two purposes that the Brown lecture is supposed to serve. That is all by way of explanation. What I hope to do in the 25 or 30 minutes that I have is to advance two claims about the way that nations are regulating new digital technology. The first of the two claims that I want to advance is that understanding the output of national regulators with respect to new digital technologies, and in particular AI, is impossible without accounting for the international geopolitical context in which such regulation emerges, right? So the national does not stand in isolation from the international, and instead one needs an account of the nature of that relationship. That is the first claim that I will aim to put on the table. The second is that there are different ways of modeling the kind of regulation that one would predict emerging from different nation states. One can opt, for example, between an ideological model, a model that predicts what a nation will do with respect to digital regulation based upon its commitments, ideological commitments with respect to regulation in general, or one might look instead at the cluster of institutions and actors that are pressing and jostling for different forms of regulation and try to offer general characterizations of those clusters, right? The latter would be a political economy account. The second claim that I want to tender is that the leading model of national regulation with respect to digital technologies available today in the literature is an ideological model, but that ideological model is not a helpful guide to states' behavior in this domain, and that instead we need to adopt a lens that accounts more fully for the political economy of different jurisdictions. And one of the things that the paper does that I will not do is advance in some detail, or in a little bit more detail than I can manage in a lecture, particularized accounts of the political economy of different jurisdictions. I will give one example. I do not mean, however, in giving one example from the paper and omitting two that are otherwise in the paper, or admitting other arguments and details that are in the paper, to avoid discussion of what's in the paper. Absolutely, if there's something that I don't talk about and but that it either resonated or you thought was incorrect that's in the paper, I'm more than happy to put it on the table. But the output of that second claim is that rather than thinking about ideologies, in modeling and understanding what a particular jurisdiction will do in digital regulation, one needs to identify and characterize the relevant, what I will call, techno-political elite. Right? And it's the nature and the orientation of that techno-political elite that I think is crucial for understanding and predicting the path of regulation. In advancing that second claim, I am in explicit conversation with one of the books that's under review here, a book called Digital Empires by my former colleague and friend, Arne Bradford. I will, as is the nature of academics, be critical of some of Professor Bradford's claims, but I want to clarify or underscore at the beginning of my remarks that there is an enormous amount in Professor Bradford's book and her work more generally that is of great value, of great insight. I learned a tremendous amount by reading the book, and I'd encourage you to do the same. And in disagreeing with a particular, albeit quite central part of her argument, I'm not intending to undermine the value of the work more generally. I think it's helpful for me to situate the two claims that I'm going to make in terms of a broader research agenda and a question that I think is really core to many of the debates about law and technology that have emerged over the last 4 or 5 years. In other words, there's a meta question with respect to which the two claims that I will advance in the course of the lecture, I think, are contributing. In the last 5 or 6 years, I've written a series of discrete articles that pick up on the possibility that a right that is conceived against the state needs to be fundamentally rethought because the state is employing machine rather than human decision makers. So rights, for example, to due process, rights against intentional discrimination take on very different complexions once the relevant decision maker of the state is a machine, is a program, is an algorithm, rather than a human. Once one starts thinking about those discrete legal questions that sound in the Register of Rights, though, one is quickly forced to thinking about the larger institutional surround, the context and culture of the state bodies that are adopting machine tools, algorithmic tools, and the way that existing cultures are changed, either within the state or within large private firms that rely upon algorithmic tools. And on that second point, there's a series of articles that I've co-authored with the former Stanford professor Tina Cuellar that grapple with this question about how we should understand algorithms, not just in the abstract, but in context. And to my mind, one of the things that I have learned in writing these pieces is that there is a fault line in the literature on law and technology. And I find myself on the distinctly minoritarian side of the fault line, particularly among people who I have a kind of normative sympathy for, particularly for people who I actually, I thought that I shared a good deal of normative pride. And the normative fault line concerns what we should make of a standing element of liberal political theory in an age where machines are of increasing importance. If one reads much of the law and technology literature, what one sees is that a premise of liberal political theory is increasingly out of favor. This premise is that the state, as such, is important, not just because it is a provider of many vital public goods, but because, as people from Hobbes and Locke onwards have identified, the state presents a particular concentration of power that threatens important human interests. The dominant thread of writing in law and technology, however, situates the threat, the concern, the shadow on human capabilities and fulfillments and flourishing, not within the state, but within the private sector. Exemplary of this literature is somebody like Shoshana Zuboff, used to teach at MIT, who has written an eloquent polemic against what she calls surveillance capitalism. The AI Now Institute, which is affiliated to New York City, rails against the handful of unaccountable big tech companies. This literature calls for legal reform, but it is typically legal reform that dramatically empowers the state. And the question that I have found myself grappling with repeatedly in the discrete projects that I've been engaged in is it wise to think about the threat to human flourishing today as solely coming from, or principally coming from the private sector when it comes to technology? Has the state-focused orientation of liberal political theory from Hobbes and Locke onwards fallen by the wayside? In other work, I have suggested there are reasons for thinking that is not the case. And this work is about thinking about, or focuses on the question of, if we think the state matters, if we think the central question of liberal political theory, which is how do you control Leviathan, is still a pertinent one, exactly what is it that Leviathan is doing? How do we conceptualize Leviathan's work when it comes to new digital technologies? All right, that is a way of understanding the question that I'm asking in the context of a larger, scholarly agenda, not a larger political agenda. I don't have a larger political agenda. And hopefully what I will do is make some progress on the question of how we conceptualize, how we think about the state and the way that the state either uses or regulates new digital technologies, in particular AI, in the current moment, right? That's the question that I want to ask. But that bigger problem of what to do with liberalism's first question is lurking in the background, at least in my thinking. Okay, with that context, let me give you the two claims that I want to advance. The first claim, I think, has a self-evident, even banal feel to it. This is the claim that national AI regulation, the European Union's AI Act, Canada has a measure that has been introduced, the AIDA, maybe it will be passed next year, maybe not. The United States has various proposals that have been floated. We just in class talked about the AI Bill of Rights, right? All of this national level regulation, or supranational, in the case of the EU, should not be thought of in isolation. You can't think of what America is doing just in American terms. You can't think about what Europe is doing just in European terms, same for China. Rather, what each state, nation state, and I'll use nation state knowing it's a simplification with respect to the EU, what each nation state is doing is a function of its geopolitical environment. Consider a couple of examples from the American context to prime the question. In the United States, there have been years of debate and high-profile congressional hearings featuring figures such as the Facebook whistleblower, Frances Haugen, and the OpenAI CEO, Sam Altman. And at the close of each of these hearings, there are bipartisan calls for regulation. And the United States has not produced a comprehensive or even nearly comprehensive measure with respect to AI, notwithstanding several efforts by legislators to do that. Or so the conventional wisdom goes, right? The conventional wisdom is, well, the reason that Congress can't act is high levels of polarization between the two parties that make pretty much everything else impossible. It's really hard to get legislation passed in Congress given high levels of polarization. There's a lot of truth to that account, but it doesn't capture everything. If we pay attention to what actually Congress does, we see there are moments at which Congress can regulate in a bipartisan fashion. One example, in April of this year, Congress singled out one of the most popular social media platforms among young Americans, TikTok, and mandated that its Chinese owner, the ByteDance company, divest within 270 days, hasn't happened yet, or else face a permanent ban on TikTok. Teenagers in my circle say that that will never happen. Ostensibly, Congress's motivation for selecting TikTok among other social media algorithms was that there was a distinctive risk that personal data circulating or created through the use of the TikTok app would find its way to not just a foreign-owned company, but a foreign state, and in particular, China. That is, the geopolitical risk, or the perceived geopolitical risk with respect to TikTok, was the solvent that permitted bipartisan regulation. Go back a couple of years. In 2022, Congress passed President Biden's CHIPS and Science Act. The CHIPS and Science Act contains $39 billion in manufacturing incentives for semiconductors and other kinds of electronic devices. Out of that, $2 billion is for, just as an example, chips in the automotive sector. In addition, the CHIPS and Science Act creates a 25% investment federal tax credit for capital expenditures pertaining to the creation of new semiconductor facilities within the United States. Explaining these expenditures, which even in US terms are not trivial amounts of money, Secretary of Commerce Gina Raimondo said in February 2023, well, global competition, particularly over technology and chips, rather than tanks and missiles, makes this statute necessary. Again, the fact of geopolitical competition explains the emergence of legislation in a period of general gridlock. So these examples of the ways in which domestic regulation occurs in the shadow of what is happening internationally can be reiterated. You can do the same exercise with Europe, you can do the same exercise with China. And the point that emerges from that observation is as follows. All nations are now simultaneously operating in a domestic political environment dominated by usually large firms that are competing to expand their market share, to monetize their technologies, and at the same time in an international environment in which states, not firms, states as such, are competing with each other to cultivate and employ various technological capabilities for geostrategic ends. How do we think about the interaction between the two? Well, what I think is a useful model is one that was offered a couple of decades ago by the political scientist Robert Putnam. Putnam said, look, you should think of the domestic and the international as almost like a split-level chess game, where the national executive is simultaneously playing one contest domestically with interest groups, with political allies and political opponents, and at the same time is sitting at the international table and playing a different chess game with their international geopolitical enemies and allies. And for an agreement to emerge at the international level, you need a certain amount of consensus at the domestic level. The international leader, Putnam points out, can use the threat of a veto at the domestic level in order to create or force certain outcomes at the international level. Conversely, what we see in the US example is that the shadow of the international level can feed into and shape what is happening at the domestic level. So the domestic and the international can either serve as accelerants, or they can serve as brakes, as constraints upon each other. But the important fact is that they are interacting And one cannot think about one level without keeping the other one in mind. Okay, that's the first claim. That's the idea that there is a distinctive interaction between the national and the international. Once we have that model in view, we have a second question. How do we conceptualize national dynamics, national level dynamics, for the purpose of understanding and predicting how nations will respond to these international pressures? What should we understand is going on at the national level? My friend and former colleague, Arno Bradford, in what I think is will be an important and in some sense agenda-setting book, came out earlier this year, called Digital Empires, makes an argument about how we should conceptualize what's happening at the national level. And I disagree with that argument, although I want to, again, emphasize how important and how insightful much of the book is. Here's Professor Bradford's claim. There are three digital empires. An empire is a regulatory model that provides a competing vision of how the digital economy should be organized. There are three digital empires offering three visions associated with the United States, Canada, and the European Union. Each of these three digital empires is animated and explained by a model. It is not institutions, democracy, non-democracy. It is not material interests that explain what countries are doing. It is ideas. America, China, and the EU are motivated each by ideological commitments to certain styles of regulation. So the United States has what she calls a market-based model that centers on protecting free speech, the free internet, and incentives to innovate. China has a state-based model that aims to maximize the country's technological dominance while maintaining social harmony and control. She often calls this an authoritarian model. And then finally, the EU has a rights-based, human-centric approach to regulating the digital economy, grounded in commitments to fundamental rights, such as privacy, and the notion of a fair, not free, marketplace. And it is these ideological commitments that drive what these jurisdictions, these regulators are doing. To my mind, these ideological models do not help us understand what is in fact happening on the ground. Take the two examples that I gave earlier in the talk, and the paper has a lot more examples, and I'm happy to talk about those afterwards. Neither the TikTok ban nor the CHIPS Act fit nicely within what Professor Bradford describes as the market-based model. Or neither of them are advancing markets in any straightforward way. In one instance, a single seemingly competitive firm is being pushed out of the market. In the other instance, billions of dollars of subsidies are being given to certain firms, but not the others, hardly the mark of a free market. Here's another example. China, a couple of years ago, enacted a privacy measure. Professor Bradford describes it as a way of consolidating state control. In a deeply researched recent piece, Georgetown law professor Mark Xia argues that, to the contrary, the central purpose of the Chinese privacy law is to enhance the party state's legitimacy by framing the party state as privacy's primary protector. This is not a goal that would be out of step with a democratic government, such as the United States, the UK, or Canada. Right? All of those countries could say that they're pursuing that exact goal and be recognized as and it would be recognized as a legitimate, democratically compatible goal. Or consider a further puzzle. The argument for banning TikTok is that TikTok presents a particular risk of data flight to China. However, the risk of, if you think that that is a risk, conditional on that, the rate of movement of personal data between large American companies and the Chinese state do not change materially as one moves from TikTok to other major players in the American market. Why? Two reasons. First, the United States is, at least with respect to secondary markets and personal data, committed, or it has, a weakly regulated, generally free market model. And because the secondary market in personal data is weakly regulated, nothing stops China coming in and purchasing that data either directly or indirectly. Second, the United States is also committed, or has, a generally open market in corporate control. Company A can buy Company B. And in a really terrific book, a Virginia scholar called Ian Kokas has demonstrated that Chinese companies are purchasing major American entities, either purchasing outright or purchasing large shares, large tranches in, major American entities that are generating and holding personal data. She points to examples from the gaming world. The entity that owns World of Warcraft is substantially Chinese-owned. She offers a series of examples, fascinating examples, from the health app context. Many health apps, apps that gather personal data through Fitbits or through your phone or through measuring heart rates or periods, are in part or wholly owned by China. Her point is that it makes no sense to single out TikTok, or the point is, it makes no sense to single out TikTok with respect to geopolitical risk, because the same risk of, if you think that there's a risk, or if you think that the phenomena is harmful, arises all across the market as a function of the structure of the markets that America has with respect to data, secondary markets and data, or with respect to the market in corporate control. So the forms of regulation that one sees are not well explained by commitments to the market, or really by any kind of ideology. So how then should we think about regulatory regimes? I would propose that we should think about regulatory policy emerging from the United States, China, the EU, or other jurisdictions. There are many other jurisdictions that are engaged in these questions, including Canada. We should think of it as a matter of political economy and not as a matter of ideas. Specifically, regulation is likely to reflect the interests of a dominant elite that is intent on marshalling and leveraging available institutional and material resources. These elites, importantly, cut across the state and the private sector. Indeed, it will often be difficult to tell where the state ends and the private sector begins, especially in a policy domain where technical expertise is concentrated, as a general matter, in the private sector, and where governments are often de facto dependent upon large firms as national champions for the purpose of their economic success. There are cross-cutting dependencies between the state and the private sector. In this light, it makes very little sense to think about the state standing on its own, having an ideology that it alone is advancing. Given the centrality of technical knowledge in this domain, the relevant elite should not be seen as the group that is hegemonic, controlling, deciding on the relevant terms of debate within the foreign policy domain. This is not a foreign policy elite. Rather, I would draw upon the historian Gabrielle Hecht's useful concept of what she calls a techno-political regime. So a techno-political regime, as Hecht defines it, is a linked set of people, engineering and industrial practices, technological artifacts, political programs, and institutional ideologies that act together to govern technological developments and to pursue certain kinds of technology salient policies. I find Hecht's concept of technopolitics really useful because it is not bounded by the lawyer's distinction between the public and the private. It is not fixated on a particular static group of interests or officials across different states. It's sensitive to the possibility of variation. And it recognizes that the set of institutions and interests that a particular state will bring to bear are path dependent. They are a function of histories of institutional design and technological and economic choice. put very crudely, it matters that Silicon Valley is where it is. It matters that it's in California, not in the Ruhr, not in Shenzhen, not in Allegheny County. The particular layout of interest groups determines the possibilities for creating, marshalling, and then directing resources, not just domestically, but internationally in the geopolitical sphere. And understanding those possibilities means understanding the dynamics of distinctive techno-political regimes, again to use Professor Hecht's term. Let me close by offering an account of the American techno-political regime. It's a relatively high level of generality. In the longer piece, I try and offer snapshot accounts of the techno-political regimes in the United States, in China, and the European Union, which are the three jurisdictions covered by digital empires. The techno-political regime of the United States, I would submit, is best characterized as a form of digital political capitalism. American officials and the leaders of tech firms commonly act in tandem, moved by a set of material and political interests that have become aligned or intertwined through shared histories. The intertwining happens because the American state has a long and deep historical entanglement upon the private digital economy, which yields a bilateral dependence. On the one hand, the CHIPS and Science Act is just the most recent example of state subsidies without which the so-called tech sector would not exist and would certainly not flourish. On the other hand, the American state is profoundly dependent upon technology firms, not just to act as national champions in the economic sphere, but for narrowly conceived geopolitical ends. For example, American surveillance capacities with respect to other nations is a function of where companies like WorldCom and MCI decide to build their servers. The servers through which much of the world's internet traffic traveled, at least until about 10 years ago, when this was publicized and you saw some reaction to it, were located in Virginia, in Northern Virginia, and close to San Francisco in California. And because the US government pushed companies that were dependent upon it to build the servers in the United States, a US official could walk into one of those servers, open up, I'm simplifying a little bit, open up a panel, plug in a USB port, and download the flow of data across the internet, right? So the fact of US surveillance capacity, which is tremendously important geopolitically, is a function of the bilateral dependency that exists between the state and companies. It's a function of the particular form of techno-political elite that exists in the United States. And it is a distinct techno-political regime from the one that we see in Europe, which has almost no domestic digital companies of global significance, right? There's a few, but certainly nowhere near as many as in the United States or in China. And it is different again from what we see arising in China, where there's an actor, the party as opposed to the state, that braids together, as my former teacher Curtis Millhop's work shows, braids together the state and the private sector in ways that are, to some extent, invisible from the outside. Without accounting for those relationships, without thinking about the particular form that the elite cutting across the public and the private sector is playing in a given jurisdiction, without understanding its history, and at least something of its history, at least something of its particular political economy today, we simply cannot understand how nations are responding to international pressures. We don't know what their opportunity set is. We don't know what their incentives are with respect to the international environment. And therefore, we cannot think cogently or coherently about what their digital regulatory regimes are. So the two lessons that I would take away from what I have said, and to emphasize, what I've done is try and draw out two pieces of the article or the review essay that I think are of general interest and of interest to my students from the seminar. That's not at all the whole of the article. And I am happy to talk about other things that are in the article, if you're interested. The two lessons that I would take away are this. First, don't think about regulation at the national level in isolation. Think of it as embedded in a two-level game of the kind that Putnam modeled, and think about how those two levels are interacting in order to produce inaction or spurts of perhaps unwise and unjustifiable action, like the TikTok ban, in particular cases. Second, when one is conceptualizing what a particular nation is going to do, ideas certainly matter, but those ideas are emerging from and being articulated in ways that advance the interests of a particular dominant techno-political elite. And the really hard task, which the paper scratches the surface of, but doesn't really do, and I don't want to pretend that I'm doing it, the really hard task is the granular question, or answering the granular question, of what exactly those techno-political elites are, and how we best, in a parsimonious and tractable way, model them in ways that give us insight into the pattern of global action and inaction around a set of really important questions, questions that affect everyone in this room who has a cell phone, who uses social media, who uses algorithms in all their ways, shapes, and forms, of exactly what the regulatory landscape, the global regulatory landscape, is going to look like. Thank you so much, and I look forward to your questions. I will confess I don't know how questions work. Do I ask them, or well, do I just defer? I'll defer to the team.
I'll give you some help. I'm sure. So thank you very much for the fascinating talk, and I'm sure we're going to have lots of questions. And we have two. So Leora, you can go first, and then Mary. Does she need a mic or no?
Yes. Thank you so much, Aziz. That's a really wonderful, thought-provoking talk. It's a good thing to come out of the children's music class into this. So there's just an issue, right? So the EU is not a nation state, which I know you know, right? So it's a regional entity governed by law, and the reason I'm raising this is that the relationship, the notion of the nation state in your political economy model plays a big role. So I'm trying to work out how you place the European Union in this framework. And one of the things, having been I am partly involved in some of the European Union digital regulation stuff around child sexual abuse images online. And one of the things that I've experienced is that the way that the idea of privacy governs EU's motivations and thinking through their conceptions in treaty law does play a big role in practice, in ways that it wouldn't necessarily play in a context where governments are governed by constitutional norms. And so it's because it's a treaty-governed entity that is regional, and it's because it is not a nation state that these norms play a particularly outsized role in the way that the language is framed. So I'm wondering about your political economy model in respect of the EU.
So I think that a way of generalizing the question is, in what ways is the EU akin to a nation state? And in what ways is it different from a nation state, such that a political economy account of regulation, either of digital matters or more generally, has to vary when it comes to the EU as opposed to other states. So to my mind, the question or the point that you raised, which is the centrality of questions of authority under Maastricht or the like, for particular regulatory actions, has, at least in the American context, strong parallels to questions of how authority is divided between the federal government and the several states. And indeed, although you don't see those play out in congressional debates over regulation, you are seeing those questions of the division of authority, the kind of the foundational question of allocation of power between different levels of government playing out in debates over Colorado's AI Act and California's proposal, which was vetoed last week by Gavin Newsom. So there are, I think, at least in the US case, I don't know enough about the China case, differences. I think that I would focus a little differently on gaps between the standard form nation state and the EU. I would push on two slightly different margins from you. It's a way of kind of extending your point and giving it even a little bit more bite. So I think we have to focus upon the EU because it's the source of the regulation. It's the relevant regulating entity. However, it is a different kind of regulating entity from a nation state for a couple of different reasons. The first is that it doesn't have much administrative capacity at the central level, right? Almost none, right? I understand Canada has its division of administrative capacity between the states and the national level. America has its, right? Wei and I were talking about the allocation or the shape of the state pyramid in China. In every context, there's an arguable paucity of regulatory capacity at the top, but maybe in the European context, it's substantially greater. So I think that that's a really important difference, which leads to a dependency upon national regulatory authorities that we've seen playing out with respect to the GDPR, for example, and the outsized role that the Irish Data Protection Agency in its inaction has played there. Right, that I think is an important dynamic, which I don't think has quite the parallel in other places and distinguishes the European case. The second element, which I don't quite know how to synthesize enough, is, to my mind, a necessary element of the nation state is fiscal capacity, right? The fact that it creates and controls, to some extent, money supply and public debt. And in the absence of public debt, you don't have a state, right? This is a lesson of the Douglas North, Barry Weingast sort of path-marking piece about the English Glorious Revolution, right? Without public debt, unless you can raise money, you are not an effective state. And the European Union is this very bizarre structure where you have monetary power, the euro, and a European central bank, but no fiscal policy. And that means, and this is connected to the administrative capacity point, that means it's sort of a state without one of the levers that I think of as being necessary to make something a state. So I would point to those two things, and actually I think that they supplement and push further your point that the EU has this really distinctive kind of institutional framework in which what I would characterize a technopolitical regime is emerging. Right, but I think that I would think that the point that you raised is a relatively. I think there are parallels to the point that you raised, at least in the American, perhaps in the Chinese context. But I think I would sort of say that no, your point is more forceful because of these other structural qualities of the EU, which are absent in more fully developed nation states like the United States, China, Canada, et cetera. And I think that you would have to think through those things before articulating exactly what it is the relevant technopolitical elite is in the European Union.
Mary, we're next.
Thank you, Aziz, for your talk. I'm Professor Ravenstein here in Mallard Law. I will confess, I read your paper. I was always a little distracted when I came to the word geopolitics because I've been watching slow courses lately. And whenever security risks and geopolitics merged in your paper, the world-weary figure of Gary Oldman came up before me, and I went on another path of thought. But I hope this was not orthogonal, but I want to go to the end of your paper where you were talking about conflicting technopolitics and context and digital regulation, how there are a lot of fields that are intertwined, and you ended with the discussion of energy security, and I thought that was really super interesting as a trajectory of where your typology might go. And it made me think about democratic security and technopolitics. And so in Canada, we have a commission underway where we have foreign interference in our electoral system. You and the states have an election coming up.
Noticed.
I hope we've all noticed. We've moved from a world where we don't really hand count votes anymore and where we have Dominion voting systems having electoral hardware and software. So I guess I wondered what your typology and the conflicting technopolitics, how that might work in this domain of democratic security and human welfare. Is there one of those models that you think is more apt, that's more predictive of where the US might go or where a country like Canada might go, but what a mix might look like, for example? Or since I think we would all agree that that democratic security is a very special concern for liberal democratic states of this age.
Yeah. Okay. So I freely concede that the absence of Gary Oldman from my paper is a irremediable flaw. Any paper that you can work in Gary Oldman is necessarily a better paper. It's a really great show. You should watch it. The books are great too. I think of the two issues that you've raised as standing at different sides, so to speak, of the challenge faced by a given technopolitical elite, even within a democratic country. On the one hand, I would characterize the politics of energy as a supervening constraint upon the opportunity set of that elite. I think that it is an important constraint with respect to technology, and in particular with respect to technologies such as AI, because, as actually we were talking in class just now, the production of particularly large generative tools and the application of large generative tools requires increasingly massive amounts of energy. So I think in the paper I have some statistic from California to the effect that generative AI uses 1 to 5% of the electricity that California uses, which is a spectacularly, I mean, that sounds like a small number. That is it. Remember, California, fourth largest economy in the world, if it was a country. It's a huge amount, right? And in Europe, energy, take Europe, for example, energy is already in short supply, right? Europe depends upon the two, I think it's now one operative pipeline to Russia for natural gas, right? There are some jurisdictions, like some of my students pointed out, within Europe that have endogenous autochthonic energy supplies, particularly around the North Sea. Not clear they're enough to supply all of Europe, and not clear that those countries have the interest to supply all of Europe. Increasingly, the energy constraints or the availability of energy and the geopolitics of energy will be just a fixed constraint upon what a given techno-political elite can do. And the work that I have benefited from the most in thinking about this is a scholar called Helen Thomas, who I believe is at Oxford, maybe at Cambridge. He's a political scientist who has a terrific book called, I believe it's called Fracture. If I'm remembering the name of the book correctly, where one of the central claims she makes is you need to understand the politics of energy before you understand the politics of anything else geopolitically. And I think that that is true of technology and in particular AI. So energy is at the front end. Democratic regulation, right? How you internally organize your political system is a downstream function of what your opportunities are. And absolutely, the way that technology filters in to systems of political control or legitimation, and I deliberately used a phrase that does not just include democracies, but also includes at least de facto non-democratic jurisdictions, right? Those capabilities are a function of what the what your inputs are in terms of technologies, and what you do with those inputs depends upon your technopolitical elite, right? So in the United States, the dominant and the two forces that I think are producing the set of concerns to which you're referring to is first the existence of large firms that have commercial interest in supplying the voting infrastructure, right? Which to my mind is not, I don't see that as much of a problem. I don't see that as much of a problem. But where it is a problem is the fact that it's overlaid upon a political fragmentation of electoral management between the US, the federal government, the states and localities. So I will tell a small personal anecdote here. I do a lot of work in Wisconsin because I do a lot of political work in Wisconsin. I live near Wisconsin. And in Wisconsin, the national election is managed, like almost everything is managed at the level of the village or the municipality. And there are 1,800 municipalities or villages in Wisconsin, which means there are 1,800 elections run under literally different rules in the next month. That fragmentation produces something that is distinctive and peculiar and amenable to a certain set of dynamic problems, not because there's a dominant faction that's controlling the election, not because there's some bureaucracy that's determining this is how these technological possibilities get used, but precisely because we don't have, in the United States, a coherent bureaucracy of election. Great to have a coherent bureaucracy of elections, right? It would be far, far better than the system that currently exists, at least if you think that bureaucracy is not amenable to political capture. Right? And now we're getting into my work on democracy and its various discontents.
We have Shpriya, and then student, and then Gia.
Thanks so much for a fantastic job. I'm glad to remember here. My question to you is, right here, the conceptual lens that you're employing of technopolitics, what does it teach us in addition to the relationship or partnership, close partnership between corporations and states, such as we understand it traditionally? And the question has a basis in the example that you cited on TikTok. So you're saying that the TikTok ban is without justification. And in my mind, I'm thinking it's not totally without justification. There is a justification that is inarticulate. So the justification is not being offered as a real justification. So there is a hidden justification underneath. And that suggests to me is better explicable in a conceptual lens that sees the corporations and state as in partnership and related entity. So I'm wondering what's the concept of technopolitics teaches us?
Yeah.
How does it help us to understand, apart from the fact that it relates to technology and AI and so on? Thank you.
Yeah, no, that's a great question. So let me offer a general observation and a specific one. And concede at the front that I think that the question is a very large one, and there are a number of different fruitful inquiries that can flow from it. One lesson that I take from, and it's not in the paper, but one lesson that I take goes back to my framing of what I characterize as the central question of liberalism. Central question of liberalism, and Hobbes does pose this question. I think Hobbes is often described as being an absolutist. He's not. There's more sort of rule of law stuff, as David Eisenhower has argued, more kind of comfort with democratic legitimation in Hobbes than people give credit for. But the problem for Hobbes and Locke is the problem of the state. How do you prevent, you don't want to be devoured by lions, but are you going to give yourself over to be eaten by polecats? That's Locke's phrase, right? That's the problem of the state. And I started out by saying, well, I think the state is much more central than Zuboff or others in that matrix think. And I think that their exclusive focus upon the private sector is a problem. But then when I come back to thinking about, well, exactly what do I think the state is? I have a formulation or an account of the state where the borders between the state and the private sector are porous. And I think they're porous as a matter of money, right? And I talked a little bit, and I talked a lot in the paper about money flowing between the state and the private sector. They're porous with respect to data, right? So I have a student who used to work for Palantir. Palantir is a company that provides immigration-related services to the United States. Immigrate DHS, and the student tells me that when Palantir provided a service, his bosses told him, always make sure that you can take whatever data is in the government database you're working and keep it, because maybe we'll use it downstream. There's so much data flowing between the two. Particular affordances, apps, capabilities are flowing between them, and people. The United States, at least, is characterized by a pervasive set of revolving doors between industry and government. And so the challenge for me is that I see the state as being really important in terms of human flourishing and liberty, both in a positive and a negative way. I see this literature that ignores the state, that just says, give the state more power, give the state the power to regulate. Don't worry about the state, which I think is not right. But at the same time, when I return to conceptualize the state, I think I find myself with a much more complex, blurred, and ambiguous picture of where the state begins and ends than I had at the beginning. Right? And I think I'm still struggling to find a way to reconcile that kind of obscured and blurred image of the state with my normative prior, that Locke and Hobbes were onto something. You can disagree with lots of other things they said, but they were onto something by saying, look, the state is a problem here. And then with respect to TikTok, I do think you're right. I think that there are two things that are going on in the TikTok legislation. The first is insiders versus outsiders. So the fact that ByteDance is not really able in the same way to lobby the US Congress as Meta or as Google, X, that's a whole other story, I think is playing a role there. So the fact that there's a thickly woven net between some companies in the state, but not others, is explaining the regulatory pattern. And as I say in the paper, there is an ideological scheme over it, and it's an ideology it's a racist ideology. It's the yellow peril ideology that I think can be mobilized in politics by these companies. But I think it's being mobilized instrumentally, right? When they ship capital to China, or when they look to China for large pools of investments, right? China has enormous reservoirs of American dollars, right? These companies are not making yellow peril arguments. They're doing so when it's instrumentally valuable for them. Right. So I think I would nest the TikTok example both in terms of material and in terms of opportunistic ideological deployments. And I think that those flow from the model. But I think that's the specific, but I want to really acknowledge the sort of the general difficulty that your question picks out.
The hour, let's just one more question, and then if others want to catch Aziz after the talk, that would be preferable. So, Black Quitty.
Thank you so much for your presentation. My name is Julian. I'm a 1L student here in Allard. I also lead some of the AI governance initiatives at the Center for Media Technology and Democracy at McGill. And one of our key projects involves looking at how we can increase more participatory democracy around AI governance and regulation. I'm just curious, one of our projects is, for example, around a citizens assembly around AI, where we're getting citizens together to talk about AI and directly participate in its development. With your lecture kind of centering around this idea of the techno-political regime as well as the techno elite, I'm just curious if you see a role for more participatory democracy in the development of regulation around AI, or for civil society to play a role within that relationship between state as well as firms to produce more perhaps accountable, democratic, and grassroots approaches to the regulation as well as development of law around AI. And an extension, is there a role that model could play at the global level? Can people provide input in how AI is regulated or norms around AI regulations exist at the global level or global governance level?
So I think those are really terrific and interesting questions, and I don't have great answers for them. So part of the reason for focusing upon political economy is in trying to identify and map out the forces that are dominant. And part of the reason I take it for the framing of community involvement, the framing of more democratic or grassroots engagement is the sense that there are certain interests, certain people who are systematically not part of the dominant technopolitical elite, right? Think of my project here as just explaining, right, not just diagnosing, right, how that pattern of lockout occurs. And then what you're saying is, well, okay, now we have a pattern. We understand how certain groups are being locked out. How do you remedy that? Right? I don't have a great account of that. And I think I don't have a great account because it's very hard to think of instances in which there has been a successful redistributive regulatory measure that changes the contours of the technopolitical elite to make it more inclusive and less concentrated in its character, less of an elite reproducing itself. I suspect that the techniques for doing that are going to be specific to different fields. And I'm happy to talk afterwards, but I have a paper that is not posted yet, but is written on, are there different ways in which platforms, online platforms, social media platforms, can be designed that makes them more open at the level of governance to a broader array of interests, makes them more responsive to a broader array of interest, or to a broader set of values beyond the realization of profit. And what I do in that paper is I draw upon a literature in the development context on what are called islands of integrity. So the idea is you can actually seed effective bureaucracies within generally patrimonial societies or governments and effectively grow good government from within. And so what I try and do there is I say, look, here's ways of thinking about islands of integrity in the public sector. What can we learn? What can we transpose over from those experiences, which are now 30 or 40 years old, into the algorithmic platform context? And I do think there's some lessons, but I think it's hard. And I don't think that it's the same set of tools that you would use in the platform context as you would use in the, for example, building, generative AI for the people models, right? That's a very, very different thing. Okay.
Wonderful. Thank you for the engaging conversation back and forth. Thank you, Professor, for a great talk.
We can ask.
Sorry?
We can ask.
Well,